Alexandria Sarah, and this is Lawyer Talk Thursday Live. I'm with Miss Cynthia Lopez. She's an immigration attorney, and we're going to talk about the intersection between criminal and immigration law. If you have other questions about Trump's ridiculous order that doesn't really do anything, according to Miss Cynthia, check out my story, and also I'll be sending it out on our newsletter. So send me some questions here. But we get a lot of crossover, right, Cynthia?
A lot. I send you a lot of clients. You send me a lot of clients. Hey, Alex, does this person have a immigration hold?
Right.
Is one of the big things.
So what the hell is an immigration hold? What does that mean?
So what happens is that when somebody gets, let's say somebody's here illegally, they have no legal status, no visa, anything like that, and they pick up some sort of criminal issue, DWI, assault, whatever it may be. So what happens is that they'll pick them up first on the criminal side, and that's where you will come in with helping them in the criminal side. But ICE also wants to make sure that they address the immigration issue. So they will put a hold so that they don't get released from wherever they may be, county jail or wherever it may be. The hold basically sends an alert to ICE and lets them know this person may not have legal status. Don't let him go. If you're going to let him go, let us know at ICE so that we can go and pick him up.
Right. So,
or her.
Right. So practically how this happens is essentially somebody gets picked up for whatever, right? And even if it's a traffic violation, DWI, and they're held in the county jail, and their family wants to bond them out, or they're eligible for a PR bond, which is essentially a get-out-of-jail-free card if you promise to come back and take care of your case. And once that happens and they're out of county custody, then ICE detainer kicks in. And so ICE is notified, and then most of the time, I would say 99.9% of the time, they're taking into detention with ICE. And then at that point, what's the process?
So it really depends. I mean, our preference as an attorney is deal with the criminal side before we have to deal with anything on the immigration side. So sometimes our recommendation is not to actually pay the bond or not to bond out, PR out, whatever you guys call it. Because once you're in the immigration side, they want to actually have a resolution on the criminal. So our preference usually is to kind of just deal with it and then let us on the immigration side deal with it.
Mm-hmm. So something that a lot of people don't know is the laws are very different, as is what is a deportable offense, right, on the immigration side versus what's a serious or formally 3G offense or aggravated offense on the state side. Because a lot of crimes that aren't quote-unquote that bad for state law purposes are really bad for immigration purposes. Can you talk about that?
Yeah, there is a really big difference, and a lot of people don't get it, that there's a big difference between what's considered a felony for criminal purposes and what's considered a felony for immigration purposes, and they can be completely different. And sometimes people say, well, I already paid my time on the criminals. I already served my time. Why am I having to serve more time? Well, it's not so much an issue of serving time. It's an issue of us figuring out if they're going to let you stay in the country. So something can be considered a felony for immigration purposes that isn't necessarily a felony on the criminal side. So all the time they tell us, oh, it was a misdemeanor. It was a misdemeanor. It's like, well, I need to look at your criminal record because I need to see if that's going to be considered a misdemeanor on the immigration side or if it's a felony.
Do you have some common examples of that?
Well, for example, some like assault charges. So there can be some aggravating factors with assaults, like assault against a family member. I don't know if that's considered a felony. You would know.
It just depends. So if it's a vanilla, like first time you hit your spouse, your roommate, your sister, your mom, whatever, right? That is a vanilla misdemeanor. Right, it's a Class A misdemeanor for stateside purposes, punishable by up to a year in jail and a $4,000 fine for stateside. But on the immigration side, it's different.
Yeah, that could bar you. And there are two different things. I mean, if you really want to get into like, the legal semantics, there's a difference between deportability and inadmissibility. So deportability has to do with when you're here in the country and whether you can be deported or not. Inadmissibility has to do with when you're trying to get your residency, visa, things like that. So, for example, an assault, and it's aggravated by against a family member, against a peace officer, things like that, those can be considered felonies versus being just a misdemeanor on the criminal side.
So let's unpack this CIMT thing, right?
Oh.
So, right? So misdemeanor thefts for us have many flavors. Same thing with deceptive business practice. That's something like you hire somebody to do your yard work, right? And they take your money and they don't ever do your yard work. That's a deceptive business practice criminal charge. But those have separate immigration consequences. So what are CIMTs?
That's a deep question.
Okay, surface level. Let's talk about like the theft, deceptive trade practice, like in the property realm.
Generally, when we talk about CIMT, so for people who don't know, CIMT is a crime involving moral turpitude, and generally CIMTs are things having to do with like a permanent taking. So if I take this and I'm charged with
Can I please
theft,
have my wine back? Thank you.
You mean your coffee? So if I take this and I have the intent to take it forever, that anything theft, robbery, like those kinds of crimes where there's an intent to permanently deprive someone is usually a CIMT. What we look for then from a CIMT, if we think it might be CIMT, is whether that person is a resident or U.S. citizen, and that's a very important distinction that a lot of people don't get. There's a big difference between having a visa, having just work authorization, having your residency, and being a U.S. citizen. Those are different levels of legal means of being in the U.S. So what I would look at first, if you bring me something that might potentially be a CIMT, is this person a resident? Are they a U.S. citizen? What status do they have right now? Are they in proceedings? And what was the penalty on the CIMT?
So a lot of times, looking back behind the judgment, right? That's a thing in immigration law. In the civil realm, when you're asking for an expunction, when you're asking for a non-disclosure, there's certain situations when you can look back behind a judgment. So you're charged and convicted of something, right? But in certain situations, the judge can make a decision based on the actual allegations of the offense. Is that something that happens in immigration court?
Yeah, so we argue a lot of times. So a lot of times what we'll do is try and keep the face of everything very clean. So, don't plead to possession of cocaine, plead to straight possession. We don't want anything in the record that says what that drug was. We want to keep everything very clean. But the judge, after a certain point of evaluating the documents, they can look behind the judgment and see what the actual thing was, depending on the type of charge. So drug charges, sometimes they'll look behind it. If it's just a possession charge, they usually don't, but our argument generally is that they can.
So we've talked a little bit about bond for criminal purposes, right? There's many types of bond. One is you pay a bondsman to get out. The other is you pay cash. The third is you get what's called a PR bond, my get out of jail free card. So once you're in ICE custody, is there a similar mechanism? Like, is there a bond for people who are in ICE custody?
Yes. A lot of times what we don't recommend is that if somebody bonds out on the criminal side, we don't always recommend that because then they'll just be picked up directly from ICE. We do a lot of bond hearings for immigration cases. There are two basic mechanisms to get out of detention. It would be a bond or parole. Parole is usually for people who present themselves at a port of entry. So if you go to the Paso Norte Bridge, ask for asylum, and present yourself, you're considered what's called an arriving alien. And those people are, the judge doesn't have jurisdiction over their cases because they're seen as being in the border asking for permission to come into the U.S. So the only people that can release them are the deportation officers, and that would be under parole, usually. So we either do that or we do a bond hearing with a judge where they're here in the U.S.
What's getting pretty sticky right now is I have some clients that are in custody that have ICE holds for example, now they're putting ICE holds on people who have second DWIs. Right? Non-violent offenders who have maybe had a previous DWI in the past and now have a second, they're getting an ICE hold. Can you shed some light on why that's happening?
They're getting a second ICE hold?
They're getting an ICE hold for a second DWI, right? Non-violent offense. It's not necessarily aggravated, or at least in stateside eyes, it's not aggravated.
I think it has more to do with actually looking at their case. Like, you're talking about cases where they weren't apprehended by ICE in the first
Correct,
place, right?
Right.
I think it just has more to do with looking more closely at the criminal records now. Before, under the Obama administration, prosecutors, they're called assistant chief counsels, they're essentially the government attorneys. They had a lot of discretion in cases. So for example, let's say a person has been in the US for 30 years, they have 5 children born here, and they have a spouse that's a US citizen, but they can't fix in the US for some reason. They came in illegally or whatever it may be. They had discretion to say, you know what, this person has 1 DUI, or this person has something that's not like a physical criminal charge. So like a violent criminal charge, and they had discretion to say, you know what, this isn't a priority right now. This guy who just trafficked in 30 pounds of marijuana is a priority right now. There's no discretion, and there's no mechanism in place now to kind of filter that. So they kind of are just processing everything. So if they didn't get caught before, it was either luck or the timing. And now when they're getting criminal charges, everybody's just getting picked up.
Right.
And it's good in some ways, and it's bad in a lot of other ways, because it really does clog the system. We just don't simply have enough judges. We don't have enough jails. We don't have enough things in place to process those cases. So what happens is that because all of these smaller cases are getting picked up, a lot of the more important and more like violent cases aren't necessarily getting looked at as quickly as they should be. So people who should be getting deported aren't necessarily getting deported as fast as they should be.
Absolutely. And I would agree with you that we need to deal with stateside charges first, just simply because what's happened, or what I've seen happen, is my clients will bond out, or they'll find me after they've bond out, and they're already in ICE custody, right, and they're taking a voluntary departure, and then they're in their home country. And Texas does offer foreign national probation, which is basically you can get a constable to take you from the border to the court if you wanted to plead guilty for whatever particular type of offense, right? And that affects immigration, either probably admissibility at this point. But and then it's basically stay out of the country for X number of years, maybe forever, and then your probation is satisfied, right? But what's happening also is a lot of people are getting deported or taking voluntary departure, and then they just never solve their criminal cases. They're just in limbo forever.
It does create a really big problem. It creates a problem when somebody comes to our attention in ICE custody and they have pending criminal charges. I mean, it does create a problem. Our preference is to have a resolution on the criminal charges. I mean, even for judges, because if a judge is looking at someone who has been here a long time but has DUI and they ran over somebody, like a manslaughter or whatever it may be, is this person a criminal? I mean, they haven't been found guilty. Do you hold that against them? Do you not? Their preference is not to have that result, because it's not their job to resolve the criminal issues. It's the criminal judge in that case to resolve it. So it kind of creates issues where they have pending criminal charges still.
I guess I'd like to get some insight on, for example, right, we deal with a criminal charge, and the criminal charge gets dismissed, but it's not expunged or wiped from the record yet. Does the immigration judge still care about that charge, even though a court, a prosecutor, a jury has dismissed it or acquitted that person?
There are a lot of criminal charges that still count for immigration purposes. So people all the time come to us and say, well, yeah, I have a drug possession charge, but it was dismissed. It wasn't dismissed. If you had to do any classes, if there was anything that was kind of like a restriction on your liberty, you had to go to classes, you had probation, you had to check in after, or you had to plead guilty, and then later on it was dismissed, that counts for immigration purposes. That's another huge thing that people don't understand. So all the time people will tell us, well, no, yeah, I have this possession, but it was dismissed. It's like, well, I need to see the criminal record. A lot of times people don't get why we need to see the criminal record. No, it was dismissed. It was a misdemeanor. It was this. No, we have to see the criminal record.
So in your opinion, so an expunction is a magic eraser, basically, right? We petition the court, they expunge it, magic eraser, like the arrest never happened. Judicial clemency is different, deferred probation is different, but if they are eligible for an expunction, straight out dismissal, would you recommend them getting that as soon as possible?
It depends on the charge. Like I said, some charges aren't going to be ever off your record. It doesn't matter what they are. Possession is going to count. Like a possession of cocaine is going to be a possession of cocaine for immigration purposes, whether it's on your record or not. If they know that you were ever found guilty of a possession of cocaine, that's a problem. So it really does depend on the criminal charge.
Okay. And then talk about, because you mentioned cocaine a couple of times, so in Texas, penalty group 1 is your meth, your heroin, your cocaine, stuff like that. But marijuana is penalty group 2. It's a separate class. What's the difference there?
There is basically, it depends on what you're looking at. If you're filing for residency, citizenship, if you're doing it here in the U.S. or doing it abroad, it really depends on what we're talking about. But generally, anything other than marijuana above a certain amount is kind of fatal.
Right. Okay. No go. All right. Do we have any questions with him?
No, we
No
do not.
questions?
Not right now.
All right. Well, we're going to wrap it up for now, but I thank Miss Cynthia for hanging out with me. And if you have any questions, tell them how to contact you.
You can find us at cynthialopez.com. You can call us at 915-996-9070.
And
Yeah,
we'll
social
tag
media.
you here. Yeah.
All right. Awesome. Take care, guys.
Perfect. I